everybody. I'm Christina Curtis.
How are you?
Good. I'm not sure if you guys know me, but I'm Christina Curtis. I'm an attorney with the Law Office of Kathy Anderson. And Sherri Cunningham, she's a supervisor with the Law Office of Rachel Yoon. We're here today to talk about battle-ready pretrial preparation. So basically, we're going to talk about today how to prepare for a trial. Okay. First thing, setting the case up for trial. So we're going to talk about right now no-time waivers, trial setting conferences, evidence, and witnesses. Okay. So when do you know that your case will go to trial? It usually happens at detention. When you're reading that detention report, you usually can pick up on cues that this is a case that's not going to likely settle. However, there are those other circumstances where a First Amendment petition comes in later, you receive new information, and that makes you pivot as well. I think we all are aware that on a daily basis, we always get new information. We're always expected to pivot. So we always have to expect the unexpected. And hence, when we get a First Amendment petition, it's a lot of times that'll change our whole entire. So what should you ask for at detention if you're pretty sure you're going to be going to a trial? First, try to consider, do you need the kids to be present? Let's say you don't know what's going to happen between now and the jurisdiction date, and you think, right now it seems that you're going to settle the case. However, there's a chance that there could be a change later on. Still ask for the kids to be present if their testimony or their statements in the report is contrary to what your clients are saying. Okay. Another thing to think about is, do you need the dependency investigator to be present? Do you need the social worker to be present? Another thing is discovery. Make any discovery request you have at that time. For instance, do you need Title 20s? Do you need screener narratives? Does everybody here know what screener narratives are? No? Okay. So screener narrative is basically where it's the call that comes into the department. So it's basically the confidential call that comes in that actually says what, it's the referral basically, okay? We can have access to that. A lot of it will be redacted regarding who called it in, but the information can be presented to us. Also the SDM tools. Does everybody know what an SDM tool is? No? Okay. So an SDM tool, that's basically the tool that the department uses to determine whether there's a risk. It's a questionnaire that, I believe it's a yes or no questionnaire, if I'm right, where it goes over several different elements to determine whether a child is at risk if placed in a parent's care. It's supposed to take the subjectivity away from the department and make an objective decision. However, what you'll see a lot of times in reports is the department will say, the SDM tool indicates that the risk is moderate. However, by looking at this, and this, we believe that the risk is low. Or no, sorry, we believe that the risk is high. That's what usually happens. Also, it's been seen that the SDM tool sometimes, although it's supposed to be an objective measure, is answered subjectively. So, for instance, let's say it's a domestic violence case and you have the mother and the dad's not living in the home. However, there's a grandmother who says, I think that he's still around. The department, instead of checking that the father's not in the home, can check, well, the grandmother's saying that he is in the home, so I'm checking yes. So the SDM tool is very important to actually try to get in sometimes to show that the department is answering questions in a subjective manner, or sometimes manipulating the data. Also, we do have access to social workers' notes. Social workers during the investigation, the dependency investigator is taking notes of the interviews. We do have access to that. We just need to file a discovery request. So all of these are potential tools that we can use. So these are the things that you should think about at detention. Are these things that you would actually want? Something else I don't have up there. For instance, there's videotape footage that sometimes you may actually want. If there's something that happened in the department lobby, let's say, if there's videotape footage, we would want that as well. Second, determine whether we need a trial setting conference before the setting of a trial date. I'll go over that a little bit more later. But basically at detention, we're really trying to set it up so that we can have everything ready to go the day of the adjudication. Okay? I'm just going to touch on this briefly. At detention, we're always having to gauge whether we're going to be waiving time for an adjudication, or whether we want to go straight forward to a no-time waiver. Okay, the things that you should consider is the amount of evidence that DCFS has to sustain the petition versus the amount of time your client needs to complete programs. So, for instance, would it be in our client's best interest for them to get into a program, show they're making progress, hence we need a little bit more time, or is it better because the department doesn't have that much evidence, so it's better for less time? I'm not going to really go over a blanket policy rule of when we should set a no-time waiver adjudication. If you do have questions about that, please speak to your supervisor about specific cases. Okay. All right, so trial setting conferences. Trial setting conferences are usually set in cases where we foresee a lot of evidence that's going to be involved for possible testimony. Okay. Under Welfare and Institutions Code, Section 350A1, the judge of the juvenile court shall control all proceedings during the hearings with a view to the expeditious and effective ascertainment of the jurisdictional facts and the ascertainment of all information relative to the present condition and future welfare of the person upon whose behalf the petition is brought. So basically, in shorter terms, they basically can try, the court has the ability to try to make things as efficient as possible, and that's why they set trial setting conferences, okay? So trial setting conferences are usually set, for instance, as a deadline for witness lists and exhibit lists, joint issue statements, and 355s. I believe, and correct me if I'm wrong, I think only Department 404 and Department 417 do joint issue statements. We do have a copy that is provided to all the attorneys here, so you guys can review those. But this is basically to really narrow down the issue, okay? It could also be used as a deadline for documentary evidence to be distributed to all counsel, and also as an evidentiary hearing. So basically, a lot of trial setting conferences are not only for, let's say, witness and exhibit lists, but it's also for the court to determine whether the exhibits, whether the witnesses would actually be relevant, or whether they're going to be admitted at trial. Okay. So, for instance, trial setting conferences are very it's a valuable tool to use, for instance, on an E case or an F case or a litigious family law case. That's when you usually would ask for a trial setting conference. I would also advise everybody not to wait for the court to set one. Really evaluate at the detention whether this case is going to need a lot of discovery. So if that's the situation, you're going to ask for a trial setting conference. Many courts instead, they usually set after detention straight for an adjudication, but ask the court to set a trial setting conference first so you can obtain all the documents that you need and be able to get witness lists and exhibit lists. Okay, so who subpoenas the tangible evidence? DCFS must provide you with all evidence within the petitioner's possession or control favorable to the child, parent, or guardian. Again, this is like what I was saying before. Upon request, DCFS must provide you with basically all the tangible evidence within their possession and control: social workers' notes, SDM tools, screener narratives, Title 20s. Okay. However, it's important to note that it's only the evidence that's within their possession and control. DCFS is not required to subpoena evidence that is not in their possession and control. So, for instance, for an E case, if the department decides they don't want to provide any of the medical records, they don't have to. If they believe they could actually prove up their E case without providing medical records, that's their prerogative. They're the ones that determine how they're going to prove up their case. If we believe we need those medical records, it's best for us to subpoena them in order to basically defend our client. Okay? So always remember that they're only required to provide evidence that's within their actual control. Okay, so who subpoenas the witnesses? Remember that 355s only preclude an absent witness's statement if there's no corroborating evidence to support it. So, for instance, if you do 355s with 3 witnesses and the county only brings 1 person in, they're not required to bring all 3 people in. They only need to bring 1 person, and then if that person testifies, then all the other statements are basically can be seen as corroborated. If you really want a witness in, don't file 355, subpoena the person in, because again, the department decides how they're going to prove up their case. So you want a witness in, subpoena them in. You don't want the witness in, file 355 just in case, you know. But yeah, so if you want a witness in, make sure you subpoena that person.
Okay. So the question is when do we call a witness? And as the slide says, you only call for information that is not contained in the report. And you should, the best practice is that you should not call a witness to reiterate what was already said in the report. You can be met with the objection of Evidence Code 352, which states that a submission will necessitate undue consumption of time. Also, if you're calling a witness and you have a particular witness that you want to call, the court can exclude that in testimony. That was addressed in Re Daniela G. I'm not going to go over the facts because it's going to be considered at another MCLE, but the important things for this presentation, the important fact for this presentation is that sometimes the court can exclude your witness. If you feel that you need it, it's a germane point that you need them to testify to. As well with an in Re Daniela G followed Jennifer J, where when Jennifer J, the court excluded a witness, and this was a hearing at a 2-6, and the mother felt that the child testifying to the bonding exception was essential to her evidence, and the court excluded that testimony. Daniela G followed Jennifer J. However, with In Re Amy M, where the testimony was excluded at jurisdiction, it was improper for the court to exclude that minor's testimony because it was germane to the issue. So the point being is that you should be calling a witness and presenting evidence for any new or relevant evidence, because all evidence no evidence is admissible unless it's relevant, and all relevant evidence is admissible subject to 352. Okay, so as Christina said, at detention you're determining what witnesses you want to call. You evaluate the need to call your client prepared to testify. And you should always prepare your client to testify, because under Evidence Code 776, any party in the case can call your client. And I'm not going to go much into the Fifth Amendment, but just to note that sometimes the Fifth Amendment right to not to testify for self-incrimination can be overruled by In Re Joanna Y, which dealt with use immunity. It was where there was a FR situation where the father didn't follow the court's order with respect to doing a 730 eval because he had a pending criminal case, and the reason why he didn't want to talk to a therapist is because he felt like those statements can be used against him in a pending criminal case. Now, In Re Mark A stand for the proposition that a parent does have a right to not testify under the Fifth Amendment. And in Re Mark A, the court there sanctioned the parent for not testifying when ordered, and this was compelled testimony and not use of a report generated by a case plan. And the court excluded his testimony and excluded any evidence that he had presented. Now, In Re Brenda M did not have the benefit of reviewing Mark A, and again sanctioned the parent by excluding his other evidence because he wouldn't testify. And in Re Amos L, that's another case where it's unsure whether the mother in that case was compelled to testify because she didn't assert her right that I'm pleading the Fifth Amendment. Her position in that case was, I wasn't advised that I had the right not to testify.
Okay, so what if the case is not ready to go to trial as expected? The Grand WIC 352, the continuance request. Okay, so The court may continue any hearing provided that no continuances shall be granted that is contrary to the interests of the minor. Okay? In considering this, the court shall give substantial weight to a minor's needs for prompt resolution of his or her custody status. Remember that the underlying goal at the end of the day is to either reunify or is for permanency. Okay? They must also look at the need to provide, again, children with stable environments and the damage to a minor prolonged temporary placements. Okay? So continuances can only be granted upon showing of good cause. So remember this, that continuances are supposed to be difficult. And I know some courtrooms grant them, I can't believe I'm using this word, willy-nilly. But yeah, so some courts grant them just, half-heartedly, but they're not supposed to. Petitions are supposed to be heard and decided rapidly. Remember, we have a, which I'm going to get to in a second, they're supposed to be heard within 60 days. If the court cannot finish the adjudication or contest a disposition in one day, the court must hear the case every consecutive day until completion. So this shows that 352 continuances are supposed to be hard. They're not supposed to be an easy thing, although they're things that we request and the county tends to request all the time. So what's good cause? Okay, because that's the first thing we need to show, is that it's good cause to continue. Improper notice, that's absolutely a good cause. Stipulation by all parties, that's not good cause. So just because everybody agrees that we're going to continue this, that's not good cause. Illness of parties, attorneys or judges, that's good cause. However, attorney vacations are not good cause. So this is why many firms, your supervisors, are telling you to make sure you don't schedule any trials on the day of your vacation, because it's not good cause to continue it if they have to appear. A pending criminal prosecution or family law matter, that's not good cause. So, and I think we've seen this where we have a client who is facing criminal charges and they're thinking, well, hey, if we just stretch this out, I'm pretty sure my case is going to be dismissed. However, unfortunately, under the actual code with 352, that's not good cause to continue. Recently appointed as counsel and you have not been given an adequate amount of time to prepare, that's absolutely good cause in RICP. But court congestion, not good cause. I wish Lancaster was here to hear this training, because this is a reason why cases out there continue so much, is because of court congestion and in other courtrooms, but that's not good cause. I understand that a lot of attorneys are assigned to one courtroom and it's difficult. Sometimes you get pushed back by a judge, but I would highly recommend that when you have a case that has been repeatedly continued, you have a client that's been waiting all day, that you make this objection under Jeff M. Renee S. versus Superior Court, that court congestion is not for a good cause and asks to go day by day. I'm speaking to the 415 crew. Okay, so with Section 352 and exceptional circumstances. So you could add, good cause is what's required for to continue an adjudication or to continue any hearing. However, if you want to continue a hearing that's longer than 60, no continuance shall be granted that would require the dispo hearing to be completed longer than 60 days after the hearing at which the minor was ordered removed or detained, unless the court finds that there are exceptional circumstances. So I just went over what was good cause. So of course, exceptional circumstances would be more than that. I couldn't find, and please tell me if I'm wrong, but I couldn't find any case law that actually discussed what exceptional circumstances were. But just understand, it's going to have to be something a lot more than what good cause was on that last slide. Okay, so in no event shall the court grant any continuance that would cause the hearing pursuant to 361, the dispo hearing, more than 6 months after the detention hearing. Okay? And unfortunately, this has happened a lot, and it's mainly been due because of court congestion, because cases have been continued over and over again because the court wasn't able to get to our client's case, and we get to this position. But in no event is the dispo supposed to be pushed back after 6 months. So even if the continuance request is made to have an incarcerated client present for the adjudication, that even wasn't enough to push a case back past the 6 months. Even if when the court wanted information and evidence from the department to actually bypass, that was not enough to push it past the 6 months. The only thing that's ever been an exception to this rule is in re AR, and that's if a parent is on active military duty. So that's the only time that that's been an acceptable excuse to push the dispo past the 6-month date, okay? So how long can a continuance request be granted for? It's only for that period of time that's shown to be necessary by the evidence presented at the hearing on the motion for continuance. So if you just need to consult with your client, it could be a week, it could be 2 weeks, but it's supposed to be narrowly tailored to the time that you actually need. In Ray Hunter W., the trial court erred in that case when instead of trailing the case just for 2 hours, so basically, if I remember correctly, I think they just wanted to come back after lunch to locate the parties, the court just continued the case, and it continued beyond the statutory guidelines. Of course, that wasn't proper. The court should have just said, okay, we're going to trail to the afternoon, and not just continue the entire case. Okay, so how do we make a 352 request for a continuance? So we usually, I think common practice in court is to make an oral request for a continuance. However, WIC 352 actually provides that if you know at least 2 days prior to the date of the site of the hearing, you know that the request for a continuance is going to be made, that it should be in writing. You should be filing a motion. Unless the court, for good cause, entertains an oral motion for continuance. So again, if you know 2 days, more than 2 days prior to the hearing that you're going to ask for continuance, it's best practice to write a motion. We have provided 2 sample motions for everybody to look at. Basically, I'm not sure if this is on those later. Sorry. Okay. If you're so basically, you just have to state the facts showing why it would be good cause and why it would be in the best interest of the child with a declaration of facts. Okay. So when is there usually good cause to ask for an oral motion for continuance? Just like I said, if it's within a day or 2 before the hearing, that's good cause. So then you could actually make the oral request. If you were appointed to represent the client the day or within 2 days of the hearing, again, that's good cause, okay? It's just the rule again, if it's more than 2 days before, do a written motion. One thing to note, I'm sorry, under 353, when an attorney is being appointed to represent a parent under adjudication and needs time to review the case, it says the court shall not continue the case for more than 7 days, which seems a little ridiculous. But you might be able to read under 352 that you could actually extend it further than that. But just beware that the court may try to hold your feet to the fire if you're appointed 1 day to represent a client to make you go forward within 7 days. Okay, and how I would respond to that if they make that order under WIC 353 is that under 352 you need more time to prepare discovery requests, subpoena witnesses, and so forth. Okay. All right, so there's other bases for continuances that are outside of 352. Of course, there's notice issues, okay? When DCFS has changed its recommendation but has not noticed the client of this change. There's untimely reports and evidence. Remember that the county must provide the social study report within a reasonable time before the contested jurisdiction hearing. It's vague. Other reports, like 21E reports and 21F reports, they're supposed to provide it 10 days. It doesn't say that for jurisdiction reports. It's just within a reasonable amount of time. So it's pretty subjective how you would actually read that. If you've received, let's say, a 75-page report, and you received that the day before your contested jurisdiction hearing, I mean, that's not reasonable time. Okay. Also note that the county must provide a disposition report only 48 hours before the hearing. So if it's just on for dispo, we only get it 48 hours before. Also, continuance of disposition when the department's recommendation is to offer no reunification services. Remember that when an adjudication is one thing, disposition is something else. So if you have a client and they're not offering reunification services, you have an automatic right to continue that disposition hearing for up to 30 days. But also remember, it's up to 30 days. So the court can say, oh, fine, you want to contest a disposition hearing? I'm continuing until tomorrow. So just understand that, okay? Yeah.
Do you have an opinion as to how that reconciles with if you're at the 6-month date for disposition already and it's a no FR rec?
I mean, I would think, so there's a different thought about this, and I'm not sure, I'm pretty sure the appellate court hasn't even touched this, but I know Judge Jackie Lewis, she used to try to argue that at detention, for instance, when you find out that the recommendation is no reunification services, she would say that that's your notice, that means you could have your adjudication and your disposition on the same day. So that is something to be careful of.
Yeah.
I would try to argue that that's not how you read it, but that's what she would always, that's what she would always say. And I'm not sure how the court will roll in that, because you do have the right to try to prepare for your disposition. Adjudication is completely different. Whereas disposition, you might want witnesses to show that your client would be safe to be able to reunify with his child. Is a different issue than the petition that's supposed to be, that's actually against your client. So, I mean, it could be argued. Okay, so many times we don't want the case to be continued. We want to go forward. Our clients want a fast result. So, objecting to 352 request for continuances, the unprepared county counsel. Because this usually happens when we have that unprepared county counsel. So these are things where you would say that's not good cause, okay? When they come in, they say, the county says, oh, we need to file first amendment, so we need to continue the we need to continue the adjudication. That's not good cause. They can file 342. They can file other petitions. They don't need to file a first amendment, and they should have been prepared. I mean, seriously. But that's not good cause. We were unable to subpoena the people listed in Counsel's 355s. Again, that's not good cause. They should be prepared on their cases. Oh yeah, okay. So there is an exception to this. When a minor is in custody, the court may grant a continuance of up to 10 days if a witness is unavailable. But otherwise, it's not good cause. We need a statewide for a father who's in custody. Well, if you have another father, you can still go forward on your father's case. The whole matter doesn't need to be continued. It can be bifurcated. Something else to take into consider also is taking the offensive approach. Try to be proactive. At detention, if your client says that there's ICWA, you know there's going to be an ICWA notice issue. There's always ICWA notice issues. So maybe make some requests regarding that at the detention. If there's a father whose whereabouts unknown, maybe you should make the request for due diligence if you want this to happen in a timely manner, because a lot of times these are things that we can see happening. Sometimes the county counsel doesn't see it. Sometimes these orders aren't made, so we have to make these requests. If there's a statewide, if we need a statewide for a father's in custody, if you notice that a father's in jail, you represent mom, you want to make sure you go forward, inform the court, say we need a statewide for the father in custody. I understand we don't represent that person, but again, all these things could help us be more efficient and be able to kind of tie in with the timelines.
Related to your first bullet point about first amended,
Yeah.
what are your thoughts when we go in and it's the adjudication and that's the day that DCFS files the first amended, and we aren't ready to go forward on the first amended petition, but we were ready to go forward on the original one?
So this is where I would say I would ask that the court not file it because it's untimely, and they could always file a 342. But it's something that you would have to, I mean, you'd have to consider. Is it going to end up, if you ask for it not to be filed, is it going to end up prolonging the situation later? Is it going to end up being where you have to do two similar adjudications? That's one thing, because then in that case you might want to say, okay, fine, let's continue the case. However, if it's something where they're just adding an additional allegation that has nothing to do with the others, I would just ask them not to file it. It's untimely. The department knew this information previously. They didn't file a first amended, and I would ask to go forward and ask them if they still have concerns, they can file 342. Because, I mean, seriously, they should be more prepared in their cases.
All right. So this is the day of trial, burden of proof and judicial notice and 350C. So roll up your sleeves, you're ready for a fight, right? Okay, so the trial begins, and who goes first? The department has the department has the burden of proving their case basically, and that's pursuant to WIC 55A. And then after the department goes, then it should be minors counsel. Now you can assist on minors counsel going after county counsel, because as you know, sometimes minors counsel will say, oh, I'll go after parents counsel. No, but you can assist on the minors counsel going after county counsel if you are going to make a 350C motion. You are not allowed to make a 350C motion until the department has rested and minors counsel has rested, and then you can make your 350C motion. So that can be a practice tip for you. And then after minors counsel, parents go next. And then we have here, I have here that parties joining with the petitioner presents evidence, but before the party defending against the petition, and that's evidence code 320. So in this particular situation, you can have the department and minors counsel on one side and maybe a parents counsel on one side, but you don't know what they're going to argue. So you will try to insist on the order that they go before you so that you can prepare to make any of your arguments or present any rebuttal witnesses. Yes?
Just a quick question. If we have a bench officer that always, or normally it's custom to ask parents counsel to argue first, can we ask them, or let that bench officer know we would like the department to argue first, or would that be okay?
The bench officer is saying you go before minors counsel?
The bench officer in our courtroom, it's generally his practice that he will have parents argue first. So parents, then minor, then the department.
Parents, then minor, then the department.
And it's normally, depending, I think, on what position he's leaning towards. If he's leaning on sustaining, he'll go to the parents first.
Okay, the court has the authority to determine the order of how it should proceed, which is what is on the next slide. So you can assist under Code of Civil Procedure that states that the plaintiff goes first, which in this case would be the department, and then the defendant, or the plaintiffs in this particular situation would be everybody who's on the side of the department. So you can assist on that, and you can cite what the authority is for that. But also,
Okay, can I just jump in real
Yeah.
quick too? So another thing that's important to note also is that the petitioner, they're introducing their evidence, they get to argue first and last. So if they want to waive opening, they can waive opening, but honestly, they can only have rebuttal at that point. So I would actually argue like fine, but then they can only argue in response to what I brought up. They can't argue their whole entire case. You get what I'm saying?
right, so on that point in your courtroom, is the department presenting evidence, their exhibits and evidence?
Oh, pardon?
How was that?
I was asking your question. In your courtroom,
We're in the same courtroom, so that's why I was. It was if the department's presenting evidence first. Generally, yeah. So they'll present their exhibits first, and then he'll direct to parents counsel. I want to hear from you.
okay. So I stand by what Christina said. Yes, Marlene?
And I think it's really critical as to when they're talking about making your 350A or 350B,
350C.
Come on, man, my age here, I got it at all this stuff. You've got to be able to get on the record and say that if county council is putting in their case in chief by just submitting the evidence, then minors counsel, you will assume, is submitting at that point. And if no one says anything, then go ahead, because you have to have that in order to make your motion to dismiss on the insufficiency of the evidence.
Right, so going back to the point where Marlene made, that is the practice tip. If he said parents counsel go first, you want to be clear that the department has rested and that minors counsel has rested. But it's going to be more about 350Cs later. So you can assist on the order, and you can assist on that order based on the Code of Civil Procedure as well. And the case law authority that goes with those propositions is In re David H. In re David H. is concerned a whole lot of information about equal notices and all of that. And in re David H., the parents, no, I think it was the Children's Council who asked was this, wait a minute, I think it was the parents' council who asked for a declaratory judgment, or is that the other one? Oh, so what happened in David H. was that after the jurisdiction hearing was heard, in the appeal, the appellant, the parents asked for a motion to challenge the petition on itself, not the substantive petition. And in that case, they were relying on the petition was not sufficient in the petition. No, I said that. That's redundant. Okay. So in this case, they were, based on their appeal, they were not only appealing the jurisdiction of finding, but also how the petition was wrote. And in this particular case, they quoted a civil procedure code, and that code had to do with whether they can actually file that motion. And in this particular court, they found that, so the question became is whether you can use civil procedure codes in a dependency hearing. And in that case, while they denied the declaratory judgment on the pleadings, they ultimately said that if it fits within the juvenile, that if it's consistent with the overall purposes of the dependency system, then you can use it. Like with In Re Claudia E., where the minor's attorney asked for a declaratory judgment against the department for untimely petitions. They will remove the kids and then not file them for 2 or 3 days. They did this a couple of times. So the public defender's office in that particular case asked for a declaratory judgment, and then it was granted. So now we're at judicial notice. Does everybody know what judicial notice is? Wake up, Donna Bernstein. You know what judicial notice is,
It's
right?
everything I said at my last trial. I want the judge to take judicial notice for this time.
Kind of, sort of. Kind of, sort of. Judicial notice is evidence in some cases without a hearing or inquiry that is accepted by the court. It is typically a well-known or notorious or indisputable proven fact. And that's Evidence Code 450 indicates that judicial notice, typo, may not be taken of any matters unless authorized or required. So when is judicial notice appropriate? Is it appropriate with prior sustained petitions? Well, let's back up. When you're at trial, the department is going to introduce a witness and exhibit list. Their exhibits are going to say detention report dated, supplemental report dated, last minute dated, jurisdictions dated, and then at the bottom they're going to say, and the court to take judicial notice of all prior sustained petitions, minute order, and court order case plan. They pop it on you, but they didn't give you a notice that they were going to use that. But you know in that court it's common practice to use judicial notice. So judicial notice is appropriate in these instances. However, if you didn't know that they were going to take judicial notice and they're asking for all minute orders, what are all the minute orders? What does the minute order say? Can I get a copy of the minute orders? You should be able to get a copy of all the minute orders. And we would know what the court order case plan is because the court ordered it and our client should be doing it.
And Sherri, can I just add something to that real quick? So there's specific cases that you should be careful of with that. The companion case, for instance, or let's say you now represent a stepdad and there is a petition that was sustained against him when he's a stepdad, and they're asking, and let's say it's under a different case number, because you know now we have different case numbers, so if it's a new baby comes in, there's a different case number than the other kid. So there's a case, for instance, now your client has this child and the department's asking for the court to take judicial notice of case plans, sustained petitions, and so forth. You don't have access to that file. You don't have access to any of that information. So that's improper. The department would have to provide you with that information. So just beware.
So when is judicial notice appropriate? Under Evidence Code 450, Section 451, the court shall take notice, which makes it mandatory, of the following. A, B, and you can read it in your slides. And then under Evidence Code for Section 452, judicial notice may. May means this is discretionary. The court may take judicial notice, and when the department asks for you to take judicial notice, they're asking under Section 452, where they're asking that any records of any court in this state, what orders they have filed. So that would be proper under Section 452D. When is judicial notice not proper? When is judicial not proper, Donna Bernstein? I'm gonna pick on somebody else. So judicial notice is
Here,
not
if you
proper.
look on page 15, social workers report such as, oh, this is key, because they will always say judicial notice of sustained petitions, case plans, so on, and sometimes they'll want to try to sneak in the reports. That is definitely a no-no from case one.
That is
Never
definitely,
allow that.
right, and I agree with Donna being a trial advocate as she is, a
Well, I try to
litigator
find
as she
something
is.
always to do.
Because in the social workers' reports are disputed facts. Those are not facts that are undisputed. Whether parent did this or whether parent did that, a lot of those, or whether the statements, those, what is in the reports are in dispute. And also, the social workers' report, as all of you have noticed, is not signed under penalty of perjury. So it's all subjective, and subjective is at dispute. What about the social workers' findings? They may find that something should be sustained, and then later on it could be dismissed. So no, we don't want the social workers' findings. So why does the county request judicial notice? No one wants to answer that
Well, they want to
question?
make it easier themselves, get away from a lot of information coming forward.
Thank
And
you.
they feel they have a good case to be able to show by preponderance of evidence that what they're falsely alleging is fake news is going to be accurate. But I have another issue that.
No, stop right there. But my point on why does the county request it, because it saves time and they don't have to do as much work in order to prove the evidence that they want the court to take judicial notice of. Okay, Donna?
An interesting issue is that when they want to bring up a sustained petition, I had a case where it was, the boyfriend was alleged to have sexually molested, blah, 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 and this was several years ago. And they alleged, and then they want to bring up the sustained petition. I said you can't do that, first of all, because he didn't have an attorney. There's a lot of ways to keep it out, so don't be fooled when they want to prove something and take judicial notice or bring it up, saying, well, he's alleged that he did this. I said, no, he didn't have an attorney, he was a boyfriend, but now the boyfriend is a father several years later with another mother. So always be aware when they're doing something to check that and see, and normally they will never give a boyfriend, an attorney, so they can try to, fool you into thinking, oh, yes, it was sustained, but always make sure you find out exactly who they're really alleging the sustained petition against in a prior case.
Right, okay. So to that point, if the department wants to exercise judicial notice of sustained petition and minute orders and case order, case plan, and you don't know, they should be providing you with the notice of that. Under Evidence Code Section 455A, if the court has been requested or has taken or proposes to take judicial notice of such matters, the court should afford each party reasonable opportunity, Civil Procedure Code, bench trial, is instructed or before the cause is submitted for decision by the court. So before the court can make a decision, they would have to afford each party an opportunity. So now you're at trial, you have this exhibit list. It's common practice in your court to do judicial notice under Section 452, but something is telling you, okay, what was in those minute orders? What was in those findings? Request it, you have the right to do so, especially if you wasn't given the required notice. Okay, so when would a parent want to request judicial notice? A parent would want to take judicial, whatever a parent wants to take judicial notice of something prior, maybe that it was a home parent or for whatever reason, they have the right to do so also under 452, under section 452. And if the court takes judicial notice under 452, then under section 453, it should be then mandatory, provided that it gives each adverse party sufficient notice of the request through pleadings or otherwise, and furnish the court with sufficient information to enable it to take judicial notice of the matter. So the point here is that the parents do have the right to request judicial notice. So we talked about mandatory and discretionary notice. Under 451, it is mandatory because it says the court shall take judicial notice. Under Evidence Code 452, when that request is made, it is discretionary. But once the court decides to take judicial notice under Section 452, under Section 453, it then becomes mandatory. Now, this case here has not Posse versus Tractor Supply Company. I think everyone has been provided with a copy of this case. It has nothing to do with dependency, but everything to do with taking judicial notice. And in this particular case, as you would see, the issue involved a judgment in a personal injury matter and then against a defendant who was the driver of a car. And so the plaintiffs in this case sued the driver as well as the employer. And what happened was they got a default on the driver, the actual driver, the employee, of a certain amount. But then they proceeded against the employer and they got a greater amount. And the employer, the defendant in this case, objected to that because the lower court should have taken judicial notice of the prior default judgment. And in the other case, and in that case, when they got the judgment against the employer, it was more money than it was in the lower court. It was the difference between $30,000. So that's Posse versus Tractor Supply. Interesting read if you want to read it. Now we're back to 350C motions. When do you make the 350C motion? And as I stated earlier, it's at the close of the department's evidence. It's after the petition and the minors' counsel has rested. Then you make your motion. And then the petitioner, which is the department, will respond. Now, why would you want to use the 350C motion? You can use it to eliminate some counts. A1, they may not have proven that, whatever A1 may be, or whatever. You can narrow the issues. But what I like about 350C motion is like when you're in a department where the minors' counsel said, oh, let me go before or after the parents' counsel, or the department waives the opening, but you don't know what they're going to say. Make the motion and then you hear what they're going to say. So I think 356 motion, the 350C motion is a good defense tool. Now, what if it's denied? If it's denied, then you start your case. You call your witnesses because you already know that the judge feels like they have met their burden, because if they didn't, they would grant your 350C motion. And this the caveat. Based on N. Ray Eric H., a parent has no right to oppose the dismissal of dependency petition against the other parent or to present further evidence if the court determines that a Section 350C motion is granted. I think we all can have different scenarios in that case when you have a family law case and your client really feels that the other parent is a risk and they want you to put on evidence to show that it's a risk. But if that parent makes a motion for a 350C, then that other parent cannot oppose that. Any questions on that one?
A real quick question.
Yes.
Okay, let's say you have, in our firm we always say, if you can't detain, you can't sustain.
Yeah.
But you've gone to county counsel and you say on the DV case where the child's been released to the mom, strike the mom from the petition. And you have a county counsel who won't do it, okay? So you go to trial and you now make your 350C to just strike the mom. Because at that point, why not? So in that situation, you are inviting the court to just strike one parent.
Right,
It's
but
to
that's,
the court, not
right.
parent versus parent. You're directing the court that there's insufficient evidence as to one parent.
right,
So if you have a situation where county council won't automatically strike the parent with it, I mean, because my position is if you don't have prima facie initially, why the hell would you ever have preponderance? So you should be making at minimum the 350C motions every single time. The county council won't automatically strike your client.
right.
That should be just knee-jerk reaction, inviting the court at that point to strike, right?
And I think that what you're saying is consistent with this case. It's just that what this case is saying, that if you're making a motion to strike your parent, then the other parent can say no,
Right.
object. That's where we're going.
Right.
Okay, so then we're here, a couple of points about 350C motions. So you know you can't make the motion, you're not able to make the motion until the department has rested and the parents' council has rested. But in
Not
in-reg,
parents' council.
okay, let me rephrase that. You know what I mean. The department has rested, minors' council has rested. Parents' council make the motion. In Ray Emily D., this is a case out of Lancaster. I like the attorney who tried this case. Well, because the department has rested and minors' council has rested, now you make your motion, and then the court says, well, I need further evidence. This is a drug case. I need further evidence about her drug testing. Drug testing was already took. I'm going to continue the case so I can get those results. Mother objected. So this case, and the court, the appellate court in this case found that the bench officer, which was in this case was Mordeski, referee Mordeski, and I probably think this case was in 426 because there was only 2 Lancaster sports back at this time. So this court upheld the bench officer Mordeski's ruling that she was able to continue the case because you are able to make what is the language that they use? What am I looking for here? The juvenile court has discretion to consider all information with respect to the child that concerns the child. Anything that's in the best interest of the child. However, that's the coffee feedback. And then there's one more point on this case, and I keep saying it. You're not able to make your 350C motion until the department has rested and the Children's Council has rested. And Guadalupe A versus Superior Court stands for the proposition that the court cannot dismiss under Section 350C if the child has not wishes to offer evidence. Closing arguments. I like this because I like when I hear closing arguments and my client said this and my client said, well, first of all, it's 2 points on closing arguments. One, you don't have a right to closing argument. It is not evidence. The court can take all of the evidence that it has and make a decision. That means this is 1:15, so I'll make this really quick. Okay, so you don't have a right to closing arguments because it's not evidence. In some courts, you can be denied the right to make a closing argument if you have no evidence. So again, what happens when the county waives opening? Now they're waiting for rebuttal. Make your 350C motion if you want to hear what they're going to say. And then the best practice is here, and again, you can insist on it based on the other slides, is that everybody who is against me, let them go first, so I'll have a chance to address each one of them. You like that, don't you, Donna?
I love it.
I got it. So with that, thank you very much.